Okay, think about this for a second. Imagine a world where pretty much anything of value, a piece of art, a share in a company, maybe even a bond, can be turned into a digital token. And then you can trade it instantly and securely with anyone, anywhere on the planet. Well, that's the promise of tokenization, and it's not science fiction. It's happening right now. So let's really dig into how this whole thing works.
And this isn't some niche, fringe idea cooked up in a garage somewhere. We're talking about the Bank for International Settlements, basically the central bank for all the other central banks, calling this a fundamental evolution. But, and this is a huge but, there's a catch.
Exactly. That's the billion-dollar question, isn't it? The technology is just sprinted ahead, while the law is, well, still back at the starting line tying its shoes. So how do you actually prove that you own a digital token in a way that a court of law will recognize? This is the absolute critical problem that everyone is racing to solve.
To get our heads around this, we're going to dive into a fantastic piece of research that lays out a super clear framework for making sense of it all. It really gives us a map to navigate this kind of wild, new legal territory.
The paper is called Private Law Frameworks for Tokenized Assets, and it's by Taiga Okayama and Kazutoshi Sugimura from the Bank of Japan. And these guys have done the really hard work of digging in and analyzing how some of the world's leading economies are tackling this exact problem. So the abstract basically lays it all out. It says, look, tokenization is booming, no question, but it's pretty much useless without legal stability. So the authors dive into the legal plumbing of 4 major economies to see how they're securing these new assets. And along the way, they uncover this really key difference between crypto and tokenized assets.
And this, right here, this is the core methodology of the paper, and it is brilliant. The authors came up with this 6-point checklist. You can think of it as the ultimate legal stress test for any tokenized asset system. For an asset to be considered legit, legally sound, it has to tick every single one of these boxes, from clarity all the way down to security. This is the lens we're going to be using for the rest of this analysis.
Okay, so first things first. Let's use this methodology to understand a really crucial distinction the paper makes. It basically draws a bright line in the sand between 2 very, very different kinds of digital assets. So on one side, you've got crypto assets like Bitcoin. They are all about pure, raw technological control. If you have the private key, you have the asset, period. Consent, legal agreements, none of that really matters, which is why theft is such a huge issue. But on the other side, you have tokenized assets, and they are fundamentally different. They represent real-world legal claims between actual people, what lawyers call rights in personam. These things are built on a foundation of legal agreements and trust, just with a new, shiny digital wrapper. All right, so with that distinction crystal clear, the paper gets to its main analysis. It uses the legal codes and brand new legislation from 4 key economies as its primary data source. It's exploring how these different countries are building the legal guardrails for these new law-based tokens. And this, my friends, is where the global race for rules really starts to heat up.
First up on our world tour, Switzerland. Now, instead of trying to cram a square peg into a round hole, the Swiss they invented a whole new kind of hole.
They created this thing called a ledger-based security. And what their DLT Act does is it basically says the token on the digital ledger is the legal asset. They're not 2 separate things anymore. They are legally fused together. So if you transfer the token, you have legally transferred the right. It's so clean, so purpose-built for this new digital age. Now let's hop over to Germany. They took a completely different path, and honestly, a very, very clever one, by looking to the past. Their Electronic Securities Act, the EWPG, does something pretty ingenious. It classifies a tokenized asset as property, or a Sachse in German, which puts it in the exact same legal category as a physical object, like your car or a book. And by doing that, bam, they instantly gave digital tokens all the legal protections that have been built up over centuries and centuries of property law. Meanwhile, over in France, they decided to leverage a system they already had in place for digital securities. Smart, right?
See, France has had dematerialized or basically paperless securities for a long time. So their legal update simply says that a distributed ledger can serve as another type of shared electronic registration system. It effectively creates a digital twin, giving a security recorded on a blockchain the exact same legal weight as one sitting in a traditional bank database. And finally, the United States. Their approach is pretty unique. It's less about defining what the thing is and way more about defining how you control it. The Uniform Commercial Code introduced this idea of a controllable electronic record, or a CER.
The law basically says, look, we don't care what technology you're using, we just have one question. Can you prove you have exclusive control over this digital thing? If you can show you have the power to use it, stop others from using it, and transfer it, then legally, you control the asset. It's a beautifully flexible and tech-neutral solution.
So, after taking us on this tour of 4 really innovative solutions, the paper brings it all back home, turning its focus to Japan to see what lessons can be applied there.
Right now, Japan's system is kind of a patchwork. It's relying on these really complex interpretations of old laws and a bunch of contractual workarounds just to make things function. The paper's analysis suggests a much clearer path forward. Learn from the pioneers. By creating general, clear rules specifically for DLT-based assets, drawing on what's working in Europe and the US, Japan can go from a state of legal friction to one of real legal clarity.
And that really brings us to the single most important takeaway from this entire analysis. You know, the original dream of crypto was all about replacing messy human laws with perfect, impartial code. But what the tokenization of real-world assets is showing us is that the future isn't about replacement at all. It's about integration. It's about weaving this powerful new technology into the proven legal fabric that has governed our relationships for centuries.
Which leaves us with one final thought to chew on. As these two worlds, code and law, continue to merge, the question is no longer an either-or. It's about how we write the next chapter of ownership, using both languages, together. So what do you think that future is going to look like?